The facility stay is over, or the contract is already signed. And somewhere in the back of your mind is a question that has never been fully answered. How did you end up at that particular facility? What you were not told before you got there. What follows will tell you exactly what the state of California, the state of Washington, and more than a dozen other attorneys general already knew about specific assisted living chains before your family ever scheduled a tour. The senior living industry is not designed around your loved one. It is designed around what the operating company can legally minimize while continuing to collect a monthly fee. The attorneys general who have pursued enforcement actions against the largest chains in this country know exactly what that looks like, because they have reviewed the internal documents, audited the staffing records, and in several cases, subpoenaed financial reporting that facilities are never required to share during a sales presentation. By the end of this video, you will know the specific public database where you can pull any facility chain's full Attorney General enforcement history in under 10 minutes before you sign anything. The first name on this list is Brookdale Senior Living, headquartered in Brentwood, Tennessee, and currently operating more than 600 communities across 41 states, making it the largest assisted living operator in the country by facility count. In March of 2021, California Attorney General Javier Becerra, joined by 4 county district attorneys, filed a lawsuit against Brookdale's 10 California skilled nursing facilities, alleging the company falsified staffing hours reported to the Centers for Medicare and Medicaid Services to receive artificially inflated star ratings, and failed to properly notify residents before discharge. In 2022, the case settled for $3.25 million. Brookdale paid $2.4 million in civil penalties and was required to appoint a compliance monitor. The company received 4- and 5-star ratings it had not earned. Families chose those facilities based on those ratings. They wrote that down. The financial consequence for a family that selected a Brookdale facility based on a star rating obtained by falsifying federal staffing reports is documented. The rating is what families use when they cannot tour in person, and the mechanism behind it, in Brookdale's case, was fabrication of the numbers submitted to the federal government. The second name is Sunrise Senior Living, headquartered in McLean, Virginia, and operating more than 270 facilities across the United States and Canada. A class action lawsuit filed in California in 2017 alleged that Sunrise engaged in a scheme to defraud residents and families by falsely representing in admission contracts that each resident would receive care services determined by an individual assessment, while its corporate staffing policies systematically prevented facilities from meeting those obligations. In December of 2024, a federal court in Los Angeles granted final approval to an $18.2 million settlement covering approximately 3,500 residents at 45 Sunrise facilities. The settlement required Sunrise to implement an injunction, ensuring staffing levels can actually deliver the services set out in each resident's care plan. That requirement exists because Sunrise's own internal policies had been preventing facilities from meeting that standard for years. What this data actually shows, when you look at the full settlement record, is not a series of isolated staffing shortfalls. It is a documented pattern of corporate policy applied uniformly across 45 facilities, producing residents who paid for services the company's own processes were designed not to deliver. That pattern tells you where the decisions were being made. The third name is Life Care Services, headquartered in Des Moines, Iowa, managing more than 140 communities across 30 states. The company came under scrutiny from the Department of Justice and multiple state attorneys general following a 2020 outbreak at its Life Care Center of Kirkland in Kirkland, Washington. That facility became one of the earliest COVID-19 sites in the country, with 37 documented deaths and more than 129 associated cases. The Centers for Medicare and Medicaid Services assessed a $611,000 fine after finding deficiencies constituting immediate jeopardy to resident health. Wrongful death lawsuits in King County Superior Court in Seattle alleged that facility leadership had received early warnings about symptomatic residents, but waited 17 days before reporting the outbreak to county authorities as required. Warnings were received. Families were not called. The 17-day delay is in the King County court record. The fourth name is Pacifica Senior Living, a San Diego-based operator that ranked 12th nationally before its management entity filed for Chapter 7 bankruptcy in March of 2025. In 2022, the California Attorney General's office found that Pacifica's citation rate was 3.9 times higher than the average California facility of similar capacity. A California jury that same year ordered the company to pay $23 million in a wrongful death case. A second wrongful death judgment of $2.5 million followed in 2024. The citation rate, the verdicts, and the bankruptcy filing are all in the public record. 3.9 times the state average citation rate is not a regional outlier. That is what a corporate pattern looks like when a regulator measures it. The fifth name is Enlivant, a private equity-backed assisted living portfolio that, at its peak, managed approximately 230 communities across 27 states. TPG Capital of Fort Worth, Texas, acquired the company in 2013. In 2023, the joint venture between TPG and its REIT partner, Sabra Healthcare, received a notice of default after failing to meet financial covenants. By 2024, Enlivant was laying off its corporate support staff in Chicago, and its website listed only a handful of operating communities. The collapse was the direct result of the portfolio's financial structure. Acquisition debt secured from resident fee revenue, with debt obligations contractually senior to every operating expenditure, including staffing. When the arithmetic stopped working, the communities went to a bankruptcy docket. When a company finances senior care through debt that must be repaid before care staff can be fully compensated, that is not incidental to the care failures. That is the mechanism. If you want to know how to pull the current enforcement record on any operator before you tour a facility, subscribe before we get to the action section. The next investigation covers a contract clause most families sign without recognizing what it forfeits. The deeper you go into how the Attorney General enforcement record accumulates across this industry, the more one pattern becomes impossible to ignore. The chains on this list did not generate regulatory actions because of isolated regional management failures. They generated them because the corporate structures above the facility level made decisions about staffing, billing accuracy, and financial architecture that were applied uniformly across their portfolios. The reason 5 separate national operators produced enforcement actions across more than a dozen states is not that each hired inadequate staff at the same time. It is that each operated under a model that treated direct care labor as the primary cost reduction variable and built its admissions process around representations its operations were not designed to sustain. That is not a coincidence. That is a business model. Regulators eventually document what families experience first. And what families experienced first at each of the 5 companies on this list started with a sales presentation that described exactly what they were hoping to find. Everything before this point is what these companies counted on your family never locating before you signed. What follows is how to pull the documented enforcement record before you tour. First, search the National Association of Attorneys General website, which maintains a searchable index of multi-state enforcement actions. No cost, 15 minutes. This step identifies any chain that has been part of a coordinated multi-state action, the most severe enforcement category and the hardest for a company to characterize as a local incident. Second, pull the state health department licensing record for the specific facility you are evaluating, not just the chain. California uses its Community Care Licensing Division portal. Florida uses its Agency for Healthcare Administration database. Illinois uses the Department of Public Health Facility Reporting System. No cost, 30 minutes. This shows you the enforcement history of the specific building where your loved one would live. Third, search the State Attorney General Consumer Protection Press Release Archive for the chain name and any named private equity owner or REIT partner. no cost, 20 minutes. This step surfaces financial fraud, billing misrepresentation, and wrongful death settlement cases that appear in the AG record, but not always in the health department database. Fourth, request the facility's last 3 state inspection reports in writing before you tour. Most states require facilities to make inspection records available on request. If a facility declines before a signed commitment, treat that as information. No cost, 1 call. The 4-step protocol takes under 90 minutes. According to the Genworth and CareScout Cost of Care Survey, the national median annual cost of assisted living in 2024 was $70,800. The research is free. The decision it informs is not. Before this video, you or someone the senior living industry's admissions process was designed to move past the Attorney General enforcement record without ever mentioning it existed. You now have 5 specific chain names, 5 documented enforcement histories, and the search process that pulls the same record for any facility you are evaluating. That is a different position to be in before you walk through a lobby. If your family has dealt with any of these chains, or if something in the regulatory record we covered matched a situation you are currently navigating, share it in the comments, because the pattern of what families are going through is part of the story this channel is trying to document. The senior living industry spends significant resources making sure families do not find out what you just learned. Subscribing is how you make sure the next piece of information they are hiding reaches your family before it costs them.